I think that there was sufficient probable cause here to arrest you. But I want to carry a little further the evidence that came in at trial. You have some very interesting points that you made, and quite frankly, I think, had you focused in on the things that were of interest, one of them has to do with, and the court is not going to rely much on the allegation of videotaping or recording or doing whatever in the restaurant, because the evidence on that is actually pretty weak. The arrest was made, and this is one of the reasons why the court kept trying to rein you in on beating up on Detective Carpenter in his testimony, because of the fact that indeed the search and this arrest was 4 months plus after the alleged incident, and no evidence was uncovered in a timely manner that directly linked you to this offense, based on what's in the record. So that scores somewhat of a point for you. One of the things that, had they obtained a search warrant sooner and obtained a cell phone and had that, and things like that happen. So you have a point there. Now, that doesn't mean that Mr. Calderon is lying. What it means is he testified as to what he saw, but it was not corroborated by physical evidence that the police were able to recover. Sometimes that happens, sometimes it doesn't. The store video is of really little use. It's kind of inconclusive on most of everything, except when it does show, that you folks were actually moving around the store, and at, some points briefly you may have been in each other's face, but it doesn't show anybody coming to fisticuffs with each other. So it's not particularly helpful to the finder of fact here. But acting on the information that he believed to be accurate, Mr. Calderon took action that he probably should not have taken. Should he have called the police? He's not on trial here today. Maybe a more prudent person would have done that. But nonetheless, some of this boils down to the old saying, didn't your mama tell you that two wrongs don't make a right? I find that the claim of self-defense is not perfected. Certainly, you are disturbed and upset at Mr. Calderon's advance on you and the language that he used at you. And I do not fault you for that. It is understandable, but whether or not that rises to self-defense, do you feel imminently in danger? Well, did you retreat? Did you leave? You actually did at some point leave the premises after a while. So your own testimony and observations there kind of cut two ways. They actually work against you. But more importantly, you basically mimicked the same thing, the same behavior. You used the same profanities. You used the same threat. If indeed Mr. Calderon, accepting this in the light most favorable to you and your testimony, if indeed Mr. Calderon was this big terrorizing influence, why would any reasonable person throw gasoline on the fire? Even if he was wrong in the beginning, walk away. call the police. Indeed, if he was that much of a threat, I mean, you may or may not have been justified in using physical force. And as I indicated before, you probably, you might have been within your rights to arrest him yourself and call the police. But as I started out today, violent, abusive, indecent, profane, well, in this case, violent, words that cause violent, abusive, yes, profane, boisterous, unreasonably loud, and otherwise disorderly conduct, under circumstances in which that conduct tends to strike out the word cause and use the word provoke a disturbance. So the operative word here is that the defendant's conduct provoked, prolonged, threw gasoline on the fire. If Mr. Calderon was trying to rob you, the video doesn't show that. And certainly you could have asked people, Mr. Peters, other people present, to have called the police. That didn't happen. And I have to look at the reasonableness of testimony. And I have to also look at, the evidence overall. And, I certainly concede from Mr. Calderon's perspective that if he had the perception that some stranger was photographing someone else's little children in there, regardless of, what constitutional protections may or may not apply on private property, certainly most reasonable people would feel that that is going to elevate the needle on the creep meter. And they are going to be concerned. But two wrongs don't make a right. At the end of the day, the dispositive part of this is that you threw gasoline on the fire. You are right that you have an opportunity rationally and reasonably to defend yourself, but your conduct wasn't defensive, it was aggravating. It was matching the type of words for words that were there. If he took a slug at you and you decked him, and the video would have shown that, we wouldn't be having this conversation. I'm not justifying or making a ruling on the conduct of Mr. Calderon. That's not our job here today. But even accepting it in the light most favorable to you that he was wrong, it still didn't justify your provocation of an escalation of the incident. There's where the problem was. If you were totally backed into the corner where you couldn't respond, you didn't walk away, you didn't tell somebody to call the police, you didn't even tell them, look, dude, I'm packing heat. You don't want to go there. Let's just end this. You didn't do any of that. Instead, you did exactly the same thing that he did. And, the language, as I indicated, with no other testimony, and this is the very interesting part of this case, is that I firmly expected there to be a much wider variation in the testimony than there was. But on the salient points, and except for the allegation really of the attempt to rob you, you and Mr. Calderon are almost, just as you were almost tit for tat in the restaurant, your testimony here today was pretty much consistent with each other. And to the other witnesses, to the extent that they were able to see and observe things in the restaurant, their testimony also was largely consistent. There were no major inconsistencies of note, of relevance in that. So the court is satisfied as I look at the evidence and I apply the evidentiary burden that I have to. To be clear and convincing, evidence should be clear in the sense that it is certain, plain to understand, unambiguous, in the sense that it is so reasonable and is persuasive that it causes you to believe it. Clear and convincing evidence is not a quantum of proof, but rather a quality of proof. And it seems to me that A person of ordinary intelligence, discretion, and caution would have confidence in the fact that you engaged in disorderly conduct in that McDonald's, contrary to Section 947.01 sub 1 of the state statutes adopted by city ordinance. So the court finds you guilty in that regard. Now,